All right, our second case on the calendar this afternoon is number 21205, County of Mecklenburg versus Ryan. And if the parties are ready to proceed, we'll hear from the appellant.
Honors, and please the court, Ashley Lamb, may I have permission to remove my mask?
You may.
I'm Ashley Lamb, I'm appearing on behalf of Mecklenburg County, this matter. Thank you for your time for this afternoon. I'll start by saying, Your Honor, this is an appeal from a tax foreclosure sale that took place in Mecklenburg County. The appellee, Ms. Ryan, was the owner of a property at Drakestone Court in Mecklenburg County. She was delinquent on her property taxes for 2014, 15, 16, and subsequently 2017. The county, by and through outside counsel, the Kenya law firm, filed a lawsuit to foreclose on the property, take possession of it, sell it through a foreclosure sale. And after many efforts on the county's part to contact Mrs. Ryan about her delinquent taxes, she never, in fact, paid the full amount of taxes prior to the lawsuits. Kenya's firm began pursuing the foreclosure sale and filed the lawsuit, ended up going to court, getting a default judgment entered, and an entry of default because Ms. Ryan never responded to the lawsuit. It was also served by publication in this case. I think that's going to be a point of contention that you'll hear from both sides. Yes.
Judge Wood, there might be an issue with your microphone as well as security officers.
Thank you. I apologize. I'll restate that. So wasn't the county aware that perhaps Ms. Ryan has been blind since 1992? And wasn't the county put on notice that she preferred communication through email? So wouldn't notice by publication be ineffective as it pertains to a blind person?
There's certainly argument by Ms. Ryan that the county was aware. There was some evidence in the record that it suggests she sent an email to the tax collector's office in 2014, some 4 years prior to any of these proceedings commencing. There's no evidence that the record doesn't show that the county was absolutely aware that she needed some kind of special accommodations to be able to communicate. If you look through the record, you'll see the numerous efforts to reach her prior to the lawsuit being filed, including numerous field visits, continued mail. There was like 17 attempts to mail Ms. Ryan her delinquent tax bill. I understand Your Honor's question, and it's I just don't believe that there was anything that suggested the county knew that any impurities that she may have would have caused them to be required to serve her or to provide her notice in any different way than what they did.
Regardless of the legal impact of the county having her email address, there's no argument or challenge that at least findings of fact 4 and 5 were supported by some competent evidence, correct? That's at record 182.
What I would say to Your Honor is there was some findings of fact, some evidence is supported in that she what she showed the court was she attempted to contact the county in 2014 via email. I'm not aware of anything in the record that shows that that was actually received by the county and reciprocated or responded to in any way. I would suggest that if she's emailing the tax collector at Mecklenburg County, unless there was some response, there's no way to know that that was actually received and replied to.
So, let me ask this a different way, and maybe I'll just thumb through here just to make sure. But did you specifically challenge finding of fact 4 or 5 in your opening brief as not being supported by competent evidence?
I don't challenge that the county did not email her, which is 5. As far as,
But in your briefs, did you challenge the trial court's finding of fact 4 and 5? And I just want to double check. Yeah, these are under the finding facts section.
did I challenge it in the brief?
As not being supported by competent evidence. I understand that you're challenging definitively the legal impact of that. But I'm trying to just kind of, if a finding of fact isn't challenged, we have to assume that it's supported by competent evidence. If it's not challenged in the brief, barring some other application of law that may or may not apply, but nothing I'm aware of in this situation.
No, I'm not, I cannot recall, or I do not believe that was challenged specifically as a contention. I think the way, to answer another way, to the extent that it was challenged because what the brief talks about is how many efforts the county made and then Kenya Law Firm made to attempt to serve her, not just specifically email, but in many other ways. And they did have, in fact, Kenya Law Firm it's breached in the brief that they did have contact with her via email after the entry of default was entered and after the default judgment. But prior to the law, or during the midst of the lawsuit being served, no, there's no challenge that's what.
Didn't Kenya Law Firm get the email address from the county tax collector's office?
Can you stick that one more time, Your Honor?
Do you recall, didn't Kenya Law Firm get the email address for Ms. Ryan from the tax collector's office?
That's correct, I believe, yeah.
Okay. So the tax collector's office had the email address?
They had an email address. There were multiple email addresses that were mentioned in the brief, or in the record. But in any event, Ms. Ryan stated in her own affidavit that on September 12, 2018, she was made aware of the foreclosure proceeding. And at that point, no time prior to January of 2019, after the sale had been confirmed, did she do anything to file any sort of pleading with the court?
Didn't she actually call, though, to get the payoff amount of the delinquent taxes and pay over the phone the same day?
And Your Honor,
September?
that gets to the gravamen of what is in the appellate's brief here with regard to that phone call that she alleged she calls the tax collector's office and was told that she owed $21,438.25. And this was in September of 2018. As it's stated in the brief, NCGS 105-361D states that an oral statement made by a tax collector as to the amount of taxes, special assessments, penalties, interest, and costs due on any real or personal property shall bind neither the tax collector nor the taxing unit. And as Your Honor may have read, what Ms. Ryan says she did was call the tax collector's office at the time that this matter was in the middle of litigation, was told a number by someone at the tax collector's office, then made a payment on an automated system for $21,438.25. That's not disputed. That money was then weeks later, admittedly, like 8 or 10 weeks later after that, was refunded to her. The specific date is not in the record that she received the money back. It is known from the record that she, by November 28, 2018, she had received the money back. I don't know that there was a specific date that you could pinpoint that she got it prior to that, but the money had been returned to her, and the position of the county was that the payment that she made, one, it was in litigation, and it didn't satisfy the full amount.
What was that full amount as of the date she made her payment?
As of the date she made her payment, the record does not reflect that, Judge, and I won't posture any kind of guess. All I can tell you is what the final report showed in the confirmation, or in the foreclosure sale, and that was entered January 16th, so that was some period of time later, and it included, at that time, it was $21,728.02
So the county took her money.
for the taxes alone. I'm sorry, Your Honor.
So the county took the $21,438.25, had it deposited into their account, kept her money, put her house on the market for foreclosure, got bids, and then refunded her money?
I believe that's correct. The only discrepancy, in terms of taking the bids, I believe the bids were being taken, but then the final bid that came in from Mr. Belk was not until, it was in October, so it would have been, yes, Your Honor, after the time that she made the payment online, or I mean on the phone, and then before she got the money back. Does that answer your question?
Yes, thank you.
Okay.
Is it your position, just so I'm clear with your arguments regarding 105-361D, regarding the oral statements, is it your position that that statute supersedes Thompson versus Whitehall and other related cases?
Well, there's no case law on 105-361D. So in that respect, I think it's unaddressed. Does it supersede?
Well, I think there might have to be some case law after today.
Well, there might, correct.
So give me a little bit guidance, what your thoughts are on there. Is the statute control? And if the suggestion is that it does, I think there's a problem in that Thompson says that requiring anything other than basically oral notice here says there can be nothing in that contention in reason, justice, or law. Well, now we may have something in law, but the Supreme Court's already said that an oral statement's enough, and a party can rely on it, and there's no reasonable reason they cannot, then is 105-361D even constitutional as not being reasonable as a statute?
I'm sorry, the last part, Your Honor.
In terms of it not being a reasonable statute, based on the language of Thompson. It's kind of a two-part question there. If it's superseded, can it actually supersede Thompson? And the part I'm quoting there is at 809 in Thompson.
809, I'm sorry.
Sorry, 203 NC 652. Let me get you the exact pin site on that. Sorry, the easiest thing will be, it's the fourth to last paragraph, the end of it. Paragraph starts in Beck v. Maroney.
I don't have that in front of me, Your Honor. I apologize. Can I ask the year on that case?
1932. And 105-361 does not appear, from my research, to have come into existence at all until 1971.
Right. So that's why I think the statute was written for a particular reason, and that being as close to the reason as I could find legally is that issues like an oral statement being made when the sheriff's deputy came out to the property with a book in Thompson and appeared on the property with the landowner and gave an incorrect amount. That person paid it off, and then that's what the lawsuit ensued from. But in order to prevent that from happening in the future, that's where I believe this statute speaks to it. To have a statement that says you can't rely on an oral statement made from somebody at a tax collector's office where, especially in a case where the matter's in the middle of litigation and there are other costs that have been incurred during the litigation, the amounts of the taxes can change throughout the litigation. In this case, she also had a lien from the city of Charlotte that was $2,200 some odd dollars that was part of the litigation as well, because the city was a defendant named here. And so, yes, to 105-361D, Your Honor, I believe does differentiate from that case simply because of the timeline. I think it was enacted for this particular reason. There's nothing that, to Your Honor's question, Judge Wood, about the money being refunded, that certainly was an error on someone's part for that money to have sat that long. Normally, it would seem, the adjusting would have been for it not to be accepted, but at this point, the matter was in the middle of the litigation. She did get it back. She was informed that
Did the
she
county have
refunded.
any right to refuse that payment at that time? Any statutory right to refuse payment when she made the payment?
If it's not the full amount,
Well, I can go down and pay on my taxes $10 a day if I want to. You can always put in something that's not the full amount. So do they have any right to refuse payment from her, even if it's less than the amount?
I will say that from the system that they use, the automated system, you're not able to make that partial payment. And that's what she attempted to use. And then the affidavit of Frank Worth, which was considered by the trial court.
Okay, is that information about the system not being able to accept less than what's due in the record?
No, Judge. This is just, the payment was taken, and then it was refunded because she had not paid the full amount. And the complaint that was filed and the certificate of tax due, those documents indicate she's paid the full amount plus the cost, taxes, interest, penalties. And she contacted Kenya Law Firm but never requested specifically any amount. She believed at the time she had attempted to pay, and that was good enough. But the statute that we're relying on again is that she got that statement from her testimony from a member of someone at the tax collector's office, and it was disputed that that ever represented a full payment.
And I know you're coming up on your time, but I've got an important question here. Has the restitution amount been decided?
No, Your Honor, that matter is pending for, well, I say pending, I'll take that back. That matter has not been addressed by the court. There's money in the
How
surplus
is
money
this a
on-
final judgment then? You haven't argued any substantial right. How is this a final judgment if the restitution amount's not been decided?
I believe that's a separate action, Your Honor. In order to recover restitution in a foreclosure case, a separate action would need to be filed. That's my understanding.
So the trial court's, it made a conclusion at the end of conclusion of the law, that they're entitled to restitution.
Right.
But the trial court in this case will conduct no further proceedings. That's your position. What will happen is some other action will have to commence.
That's my position on how it would have to procedurally happen, yes. I don't know that everyone else involved in the case has that same opinion, but there's nothing pending that has set the matter for a hearing for restitution before the district court.
What impact, if any, I'm looking at record page 186, the fourth paragraph where Mr. Belk says he's no longer a party. It says, because the Belk's interest in the property cannot be affected by these proceedings, Belk is no longer a necessary party to the litigation, and he is therefore dismissed as a party. Does that not indicate that the trial court's anticipating more is going to be happening here? Why dismiss a party if this is a final judgment?
Well, they may be anticipating, Your Honor, but I believe you have to file another case altogether. There's lots of discovery that would have to be conducted in order to determine what these losses are. I don't believe at this juncture in a foreclosure proceeding, nothing's been pled other than in the motion to set aside the judgment.
We're just trying to figure out if that's something that the trial court in this case anticipated doing, because if so, we may not have appellate jurisdiction until the court has concluded
understand.
everything it believes it needs to do.
I understand that, Your Honor, and I can't speak for what the trial court thought or what was on their mind. My opinion, the reason that I postured it the way I did was because I don't believe it's right to go before the trial court. That it would have to be a separate action to allege that she's lost money due to the taking of the property being improper, if that's the case.
Okay.
Hope
Thank
that
you,
answers
counsel.
the question. Thank you.
Thank you very much.
We'll hear from the appellee cross-appellant.
Thank you, Your Honors, and good afternoon. May it please the court, my name is Harrison Lord, and I represent the appellee cross-appellant Helen Barbara Ryan. And if I may, I'd like to reserve 5 minutes of my time for rebuttal. I said it in my brief, and I will say it again here today. This case represents an absolute miscarriage of justice. Prior to 2014, money that had been deposited with the clerk of court in Mecklenburg County as a result of Ms. Ryan's parents' estate had been used to pay the taxes on her home. And that had established a pattern of behavior and that led Mrs. Ryan to believe that that pattern would continue. However, in 2014, that money is cheated to the state without Ms. Ryan's knowledge. She believed that money was continuing to be used to pay the taxes. And as a result, she failed to pay her taxes. As soon as she became aware of that fact, Ms. Ryan did everything within her power to rectify the situation and to get those taxes paid. But she was frustrated at every step of the way. She was never properly served in this lawsuit. Judge Wood, I think you had an excellent question there. Yes, she told the county explicitly in an email to the county tax collector's office that I am blind, and as an accommodation, please use this email address to contact me with anything. She had asked the county to do that to accommodate her disabilities, but the county never made any effort to reach out to her at all prior to resorting to service by publication. And so as a result, on August the 1st of 2018, the trial court, relying on the county's improper use of publication service, entered default in a default judgment against her. When she discovered that the case was going on in September 12th of 2018, which is prior to the date of the initial auction, Ms. Ryan immediately took action to pay the taxes. She sent multiple emails to the tax collector's office requesting information about the taxes that she owed. But despite those multiple attempts, the county never responded to those written responses with any written response of its own. And so on September the 14th, in the absence of any written response to her written requests, Ms. Ryan reached out via the phone and spoke to someone at the county tax collector's office and obtained a payoff number, which she paid over the phone. The county keeps insisting that this was done via an online system. All of the record evidence shows that Ms. Ryan called and made payment over the phone. She made payment in the full amount that was owed, paid it in its entirety, $21,438.25. And the county received that money in full, and it was debited from Ms. Ryan's account. And so like any rational person, Ms. Ryan assumed that that would bring this to a stop, the foreclosure would stop.
Mr.
But
Lord, let me ask
Yes,
real
sir.
quick. I'm going to ask you the same question I asked your friend for the appellant. Is there anything in the record showing what the cost of redemption was on that date?
There is not, Your Honor, and despite...
Whose burden was that then? Was that the appellant's burden, or was that Ms. Ryan's?
I think it's absolutely the appellant's burden, Your Honor. They made a representation as to the correct amount over the phone to Ms. Ryan. Ms. Ryan relied on that amount, paid that amount. The county accepted that amount. If some other amount were due, the county had the burden of coming forward and saying, this is the real number. And in fact, the trial court asked the county that very question, asked the county to explain the difference, and the county was unable to do so. They've never presented a number to the trial court or this court.
So would that be, I don't recall any objection to this at the hearing, but would that be an admission by a party opponent, and therefore there would be competent evidence? I'm just trying to figure out how we get to the fact that she paid the amount.
Your Honor, it's our position that yes, it is an admission. It was an admission when the county told Ms. Ryan on the phone what the amount was. And that's the only evidence that's in the record as to what the amount was. And so in the absence of any contrary evidence at all, that's the amount. And so them coming forward, and they bring forth an affidavit in this case, Your Honor, and they say it's the wrong amount, but they never say what the right amount was supposed to be. And apparently they don't know. Did that answer your question, Your Honor?
If you win,
Yes, sir, thank you.
if you win here before this court, what are you doing next?
Well, Your Honor, in large part, that will depend on how much we win before this court.
Imagine that we conclude that we can't set aside the foreclosure, but we're affirming in all the aspects, including the finding that you're entitled to restitution under the statute. What would you do next?
The next thing we do is we go back to the trial court and we have a hearing as to the amount of the restitution.
Which trial court and for that hearing? You probably know where I'm headed with this.
I believe, and I think this is the question you're asking, Ms. Ashley as well, I believe that the court has retained jurisdiction over that. And in fact, there was a colloquy in the transcript during the hearing where Judge Havelka was interested in taking evidence on that right away, and everyone, all the parties there, agreed that at that point it was premature to hear as to the amount of the restitution, but that the restitution itself could be decided.
But in your brief, looking at page 3, under Statement of Grounds for Appellate Review, you say, pursuant to Rule 28C, Ryan accepts the Statement of Grounds for Appellate Review set out in the plaintiff's brief, which was that this was a final judgment. So is it now your position that it wasn't necessarily a final judgment if the trial court's still going to do stuff?
Your Honor, I think that it was a final judgment as to all the issues that were decided. And I sort of took my cue from the Akal case and the George case, maybe just one of them actually, where it went up on appeal and then went back down as to the amount of restitution. And so the best guidance that I had from this court was you go up on this issue, you come back down, and we decide the amount of restitution. And so that was what I assumed the correct answer was. I'm hearing the questions from this court as to whether this entire appeal is premature. Candidly, I don't have a good answer to that beyond the fact that it is in line with what has been done in the past cases dealing with this same issue. And so to the extent that it might otherwise be premature, I think at this point it's been fully briefed, and certainly from my client's perspective, we'd like an answer as to the issues that are currently pending before the court.
So you're asking us to construe your pleadings as a petition for a writ of certiorari in the event that we conclude that there's no appellate jurisdiction?
That would be my request, Your Honor. Otherwise, I think it would just be an enormous waste of time and money for everyone. So moving back to this then, instead of the case just being over, as Mr. Lamb mentioned, they went forward and they foreclosed on the house, notwithstanding the fact that she had made full payment and the county had accepted the full payment. And after a series of upset bids, Mr. Belk, the necessary party appellee in this case, emerged with a high bid on the property after a series of upset bids. And I emphasize it was a high bid, Your Honors. It was not, because he was a high bidder and not the purchaser at that point. At that point, he had not tendered payment and no sale had ever been confirmed. And in fact, believing that she had paid the taxes in full and that the matter was over, Ms. Ryan didn't find out that any foreclosure auction had happened at all until October the 31st, when Mr. Belk showed up on her doorstep and announced that he had bought the property. And at that time, as the trial court explicitly found in finding of fact number 21, Ms. Ryan informed Mr. Belk that she had paid the property taxes. And at that point, Mr. Belk assured Ms. Ryan that if she had paid the taxes, he would, quote, back away. And again, at that time, the sale was not complete. It was not confirmed, and there was no purchase at all at that point. Mr. Belk had not even tendered the purchase price. He didn't do that until November the 28th. So when Ms. Ryan told Mr. Belk that she paid the taxes, and Mr. Belk promised to back away if that was true, Mr. Belk remained merely a high bidder on the property. In the intervening time, Ms. Ryan was frantically trying to contact Mr. Kenya, the lawyer and the commissioner for the sale, and left multiple voice messages for him, sent him emails, explained that the taxes had been paid in full and before the foreclosure, and asking that Mr. Kenya stop the proceedings. And days went by without any response, but finally on November the 28th, Mr. Kenya's office responds via email at the very email address that Ms. Ryan had requested the county use for anything regarding the taxes years before, which she had easy access to. And rather than acknowledge Ms. Ryan's payment, or even tell her that some other amount was due, as Judge Murphy suggested was a possibility, rather than do either of those things, Mr. Kenya's office, which, by the way, received a total of $27,000 $896.25 for its part in this sale, Mr. Kanya's office, rather than do any of those things, says that Ms. Ryan has no right to redeem the property. And that statement was wrong as a matter of fact. It was wrong as a matter of law. At that point, Mr. Kanya's office had not even moved to confirm the judgment of sale, had not even made the motion, much less gotten an order confirming the sale from the trial court.
How do you respond to Belk's argument that there would have been a right for the county to seek specific performance of the bid as of the time it was placed?
Your Honor, I don't think it's correct. I think that had Mr. Belk backed out of the bid in a proper sale, that the county would be able to enforce his bid against him. But I think that in this situation, where there were these improprieties in the sale, where there were these irregularities and defects in the sale, that the county would not have been able to do that without first addressing the defect in the sale.
But how is a reasonable person supposed to know if the government is telling you all this stuff's been done, you're looking at the service, you shown up at the house where she was living, and, you know, late most favorable to your client, she was there and talked with Mr. Belk. Does Belk have to file a declaratory judgment action? I mean, what's a reasonable person supposed to do to become a good faith purchaser?
I think that a reasonable person, Your Honor, would investigate further and not just say, well, I don't believe her. Having been put on notice of the actual events, of the actual facts in this case, having been put on notice that she had actually paid.
But isn't that just a hindsight issue, a hindsight concern that it turned out that she was right? I mean, we don't really consider hindsight that much in the law, especially, I'm thinking, motion to suppress situation. It doesn't matter that there was, a kilo of heroin in the trunk. Was the stop proper? Just because they may have had a hunch that turned out to be correct, that doesn't matter. So I'm trying to figure out, one, how does that aspect that Ryan's right come into play here? But then what kind of burden should we hold Belk to?
Well, I think that you hold him to the burden that's set out in the law. And that burden is very simple. If you have actual knowledge, or constructive knowledge, actually, but if you have knowledge as to any defect in the sale, then you're put in a position of either, one, investigating further. That may be a declaratory judgment action. That may be as simple as checking with the county to see, have you received any payments? This woman says that she paid. It may take any number of forms. But that's one option, is to investigate further. And the other option is to do what we would contend Mr. Belk did in this case, which is to take the sale, to take ownership of the property, knowing of the defect, and knowing that you are not a good faith purchaser for value at that point. Did that answer your question, Your Honor?
It did. Thank you, sir.
So eventually, long after, over a week after, his office has told Ms. Ryan incorrectly that she has no right to redeem the property. Over a week later, Mr. Kanya's office finally moves to confirm the judgment of sale on December the 4th, does not ever mention to the trial court anything about the payment that was made, does not make any mention of any of the facts other than that they want the sale confirmed, and the trial court, in the absence of that information, enters the order confirming the sale on December the 6th. Mr. Belk then goes back on his word. He does not back away, and instead, on February the 4th of 2019, he has Ms. Ryan forcibly removed from her home by the Sheriff's Department and leaves her homeless on the street. And that's what brings us here today, Your Honors. And so my client's taxes went unpaid because of an error. She was never properly served with the lawsuit. When she finds out that the taxes are due, she pays them right away. The foreclosure action takes place anyway. The county goes forward with the sale. Mr. Belk says that if she's paid the taxes, he'll back away. The county's attorney falsely tells her that she doesn't have any right to redeem, and they take her house and they throw her out on the street. That's what brings us here today. And I'd like to briefly respond to the county's arguments, but before I do, and this may be beating a dead horse a little bit, so I'll try and be brief, but I want to focus on the fact that in order to justify setting aside the confirmation of the sale, the only thing that should matter, and the only thing that we need, in my view, to win this case, is the fact that the county falsely informed Ms. Ryan that she had no right to redeem when she clearly did. That statement, standing alone, is in my view enough to justify setting aside the judgment of confirmation. North Carolina's public policy is exceptionally clear on this point. Homeowners have an absolute right to redeem their property up to the date of the confirmation of the sale. And so when the county and its lawyer unequivocally states that right doesn't exist.
Let me ask you a question there.
Yes, Your Honor.
Perhaps we agree with you and agree it should be set aside, but the house no longer exists now. So what does your client gain from that?
From getting the house back, Your Honor?
But that doesn't exist now.
Your Honor, the only good answer that I have to that is that land is unique, real estate is unique. This is the land where my client's parents lived. Certainly, she would prefer to get her own house back. That is what she would like with all the stuff that was in it. That would be ideal. As you note, that's not possible. But in any event, certainly she is entitled to getting the land back, if nothing else.
Can I,
Sorry.
Yes.
can I get back to General Statute 1108 again? for a
Absolutely,
second?
Your
So I think, we're going to hear for your friend that there's just no remedy. There are all sorts of ways the law provides to try to make your client as whole as she can be again. But then there's a few things, just sort of red lines that can't be crossed. And one is the trial court has no authority to order the actual land be transferred back after it was sold in accordance with the judgment, even if the judgment later is concluded to be set aside. So can we get around that? Are there any equitable bases to get around that? I mean, isn't that just what the legislature told us has to happen here?
I don't believe so, Your Honor. And I believe that the George case actually explicitly did the opposite of that. And in George, the Supreme Court said that, in fact, we can take the land back. We can undo it. We can unring the bell. And the reason for that is that Mr. Belk's not a good faith purchaser because he had actual knowledge of the defects prior to the purchase of the property. And I'm happy to address that further, Your Honor. The Supreme Court in George made it very clear that the burden of proof to show good faith purchaser status is on the purchaser and not on the owner of the property. Okay, so Mr. Belk has the obligation to prove that he is a good faith purchaser for value. And he's got to prove that he was not aware of any defects in a sale. And in this case, the trial court found as fact, in finding of fact 21, that, quote, Ryan informed Belk of the paid property taxes when Belk came to the property after making the bid. And that's in the record at page 184. And that finding of fact is correct, it is uncontested, and it is binding. And so there is no question that at the time he made his bid, he didn't know. But after making the bid, there's no question that he did know.
So one question I have about that is, if you're in a situation like this where you've bought a property out of foreclosure and you go to the property, knock on the door, person said, I paid my taxes. So your position is, at that moment, you have to take that as true or you're not a good faith purchaser for value? You have to assume that everyone that says I paid my taxes paid their taxes.
No, Your Honor, I'm saying that you've been put on notice of a potential defect in the sale. And as I said to Judge Murphy, I think that then presents a potential purchaser, a bidder on property, with options. You can investigate, or you can choose not to investigate and run the risk that you're not going to be a good faith purchaser. But those are your options. And so, again, he shows up and he says, I'm the high bidder on this property. At that point, could he have gotten out of it? Absolutely. Because he could have gone to the county and he could have said, did she pay her taxes? And ostensibly, someone at the county eventually would have said, oh yeah, we have all this money that she paid right here. Never mind, the sale's off, right? And then he would have gotten his deposit back and he would have gone on with his life. He chose not to investigate. He chose not to take any action at all beyond lulling Ms. Ryan into a sense of calm by telling her that he'd back away.
Well, one other follow-up question on that is, what investigation, so the county to this day is taking the position that she didn't pay her taxes. So if there had been some sort of due diligence, what would have changed?
Well, I mean, in this case, Your Honor,
So you're just saying, had he called the county and the county said, no, we think she didn't pay her taxes, then he's a good faith purchaser, but if he doesn't make the call, he's not.
I think that even then, I would have questions as to whether Mr. Belk would be a good faith purchaser, because again, he is still on notice of the defect prior to the sale. I think that certainly Mr. Belk would have a cause of action against the county for screwing it up, and for causing him to incur these costs and expenses for property that he will not get to keep. And I think that that would be his remedy.
If he had gone to the county and requested a certification as to, or certificate as to the tax amount, and would he have been entitled under 105-361B2 to have relied on that and therefore be a good faith purchaser?
Your Honor, let me look at the statute very quickly, but I don't believe so, because I believe that that statute speaks to the owner of the property.
But this is about reliance. It talks about
No,
all
Your Honor,
persons.
he absolutely would be able to rely on it, because he would at that point have a legal interest in the property as a bidder on the property. So yes, Your Honor, he could have relied on the tax collector's written statement.
And looking at that same statute under A1 sub E, by having a bid on the property, does that make him fall under A1E?
I believe that it would, Your Honor.
Thank you.
Your Honors, I see that I'm running low on time. I would like to just emphasize before I close, again, with respect to Mr. Belk, he was on notice prior to ever purchasing, prior to ever paying a cent, prior to ever paying anything beyond his deposit to the county, prior to making payment for the property, prior to the confirmation. He knew, and he knew of the exact defect that is at the root of this appeal. And so he cannot be a good faith purchaser, because at the time he knew he was not a purchaser, he was a mere proposer.
And let me ask a question real quick regarding your estoppel argument against the county, which I found to be an interesting argument in the brief, but I'm looking back at your motion, pages 96 through 98 in the record. Can you point me into there where you raise the estoppel argument below, or is that something that's in the transcript?
Your Honor, unfortunately, because the county never raised the issue of 108, it was never before the trial court. They've waived that entirely. I would have raised that issue before the trial court had I been given the opportunity, had the county ever mentioned the statute at all. But because they waived it before the trial court, that's why we don't allow people to swap horses midstream, is because it means that the trial court never got to consider this. I never got to present arguments on it. And so I think that's yet another reason to not humor the county's request that this court even consider it.
Thank you.
Thank you, Your Honor.
All right, from the appellee.
Thank you, Your Honors. May it please the court, Amy Hunt for necessary party appellee Jacob Belk. Much of what we've talked about today has very little to do with my client. It is no secret that my client was the high bidder and is now the owner of the subject property. Ms. Ryan is taking the position that my client is not a good faith purchaser under 1-108, based predominantly on the George case. Unlike George, this is not a case of an insufficient bid. In fact, my client's bid was $407,924, approximately $340,000 of which are still sitting with the clerk. That is in the record, Your Honors, when you're talking about what options are depending on what happens today. That money still sits there and is Ms. Ryan's. This is not a case of an insufficient bid. This is also not a case where we knew she lived somewhere else and we didn't attempt to serve there. She claims to have lived there the entire time, and the sheriff knocked on that door repeatedly based on the evidence in the record. It's also interesting, the George case doesn't involve the deficiency being an alleged payment. The claim here, the sole claim that should prevent my client from being a good faith purchaser, is that my client, after submitting his bid, which I would contend he would have lost had he withdrawn his bid. He goes to the house. He knocks on the door. No one answers. She admits in her affidavit she was home and heard this, but did not answer. At this point in time, he believes the home to be vacant based on the court file. The sheriff said it was vacant when he attempted to serve there. He knocks. He still announces himself, just in case anybody's in there. If anyone's here, I'm Jacob Belk. I just bought this house. Nothing. He comes back to the property, and it was not a conversation with Miss Ryan. She did not open the door and say, see, I live here. There was a note posted on the front door that said, if this is about the taxes, I paid them. That is the statement that we are supposed to believe defeats a good faith purchaser. If that is true, every debtor in any tax sale is incentivized to post a note at the property that says, paid it. And as far as this investigation that Mr. Belk should have done, I believe your honors have already pointed out, if he'd called the county, what would they have said? We don't know, but they're contending today the amount wasn't paid. So based solely on that, we have to assume that may have been the answer Mr. Belk received. But why does he need to make that call? If Mr. Belk believes Ms. Ryan that she has paid the taxes, he knows the sale will not be confirmed, because that's the county's job. If taxes are paid during the redemption period, the sale doesn't go through, and every purchaser or bidder at a foreclosure understands that process. You put your money on the table. If they come along and redeem, you're out of luck. The original owner gets to keep title. Why would Mr. Belk have to do an additional investigation, even go so far as file a declaratory judgment action to determine that the party foreclosing was taking the proper steps? That sort of effect would chill all bidding on foreclosures across the state. Tax foreclosures, HOA foreclosures, deed of trust foreclosures. If that level of investigation is required, that the foreclosing party may foreclose even though they don't have a right to, that is such a high burden to place on bidders.
But let me ask you this way.
Certainly.
Is there anything in the record showing that your client ever got a certificate about the amount of taxes that were still outstanding?
No, Your Honor, and again, I don't believe that's something the average bidder would ever do. They know based on the tax sale documents how much is at stake. He knew how much the county was claiming as of the date it filed the tax foreclosure. And he knew he had that amount covered in his bid.
But in basically every real estate transaction, somebody gets a tax payoff or makes sure there's no taxes owing. That seems to be a pretty much the course for doing business in whether it's a foreclosure sale, whether it's a regular purchase. I mean, people find out what taxes are owing before closing and make sure that's right. That's, I mean, I can't tell you how many times I've gone down the morning of just to double check that there's nothing new on taxes, and you know, that 30 seconds before the deed, make sure nothing else has been recorded. It seems like part of the general process in North Carolina. So why is not getting a certificate related to the amount of taxes due not a simple step that we should expect of a buyer, especially when they're put on notice that there may be a problem and that the taxes were paid?
Well, Your Honor, I respectfully disagree that that's part of a foreclosure process in North Carolina currently. I agree. In real estate transactions, residential or commercial, you're going to check the taxes, you're going to double check them, you're going to make sure everything's been paid off before you close and record. This is a tax foreclosure. They have to state up front, here is what is owed. Here is the basis for our ability to foreclose. I don't understand why we would impose an additional burden on bidders to make sure the foreclosing party, in this case, a county, a municipality, really is owed what they're saying in court pleadings they are owed. That just feels like a significant hurdle. And I agree, it is definitely true in the normal transaction, but this is not a normal closing. This is a foreclosure process where the amount owed has to be stated up front. It's not like our sales price is X, how much of the taxes, what's going to come out of that later. We're simply saying, here are the taxes. If someone comes along and pays these taxes because the owner has not done so, they will be the new owner of the property.
Let me ask you about that. The certificate of taxes that was, looks like it was attached to the pleadings in August of 2018 said the amount owed was $20,775.33.
Yes,
Of
Your Honor.
course, we know that she paid $21,438.25 in
Yes, Your Honor.
September, but aside from that, the $20,775.33, was that the amount that your client was also on notice that was owed to the tax
I
department?
believe that's true, Your Honor. I don't believe he's aware of any other number that would have been owed. Nor did he know the amount she claimed to have paid. Remember, the note only said, I paid my taxes. It did not say, I deposited 21,000 blank, blank, blank on X date to so-and-so, at which point, perhaps, and we don't have these facts before us, but perhaps if those were the facts, he could say, okay, taxes were 20. If she says she's paid 21, maybe there is something here. But a simple note saying, if this is about the taxes, I paid them, go away, does not put anyone on reasonable notice. And because I think George is currently the only case out there that gets us around 1-108 and the good faith purchaser, I want to make some more distinctions between that case. In George, the court, interestingly, made very clear comment that it had a hard time believing the purchaser. The veracity of the purchaser's statements in the trial court were questioned by the opinion of the trial court. In this case, the transcript clearly shows the trial court had a hard time believing Miss Ryan did not know this was going on prior to the 18th when she made the payments. There is nothing in the record, in the order or in the transcript, that indicates she had any trouble believing Mr. Belk came along as a good faith purchaser. In fact, there are findings specifically that say Belk is a good faith purchaser in the transcript and in the order. These findings are conclusive on appeal because they're supported by competent evidence. The only evidence that he's not a good faith purchaser is the note, which, if the note had been true, Belk has no reason to believe the sale would have been confirmed or he ever would have been deeded the property.
So you mentioned one thing, just to be clear, because I asked earlier. So I'd asked if there were any mechanisms in the law to get around 1-108. So, because I think you can interpret George as not applying some equitable doctrine to escape the language, which is applying the language of the statute. The requirement of the good faith is in there. But in your view, is there any case that would support applying some equitable doctrine to say, well, the statute says you can't set aside these sales, but for some, can you think of any extreme circumstance where the court would have some power and equity to say, we're going to set aside the sale anyway?
I am unaware of any. I know George clearly did it. And I know this court back in 1990 in the Town of Cary versus Stallings case made a similar decision. Again, in that situation, the defendant no longer resided at the property, and the party foreclosing the Town of Cary knew she no longer resided at that property. Far more similar to George or even a Ka, although they didn't set title aside. All three of those cases involve the owner of the property not being at the property and everyone knowing it. In this case, Ms. Belk and all of the evidence, Ms. Ryan and all of the evidence indicate she was in the property the entire time.
But there's no finding, and correct me if I'm wrong, but there's no finding that she was actively avoiding service.
There is no finding. I believe the transcript indicates the trial court judge had a difficult time believing that she was unaware, that she had been in the property and seen sheriffs milling about and had no idea what was going on. But there is not a finding in the order. That was just in the transcript, Your Honor.
And also, as it relates to the finding, I'm looking at finding 21 on 184. Ryan informed Belk of the paid property taxes when Belk came to the property after making the bid. And that, whether we're trying to figure out, was there a conversation, was there not a conversation, at least we do know that she did inform him by at least some means, and that's not challenged on appeal. Correct?
I do not dispute that there was a note posted at the property that said, if this is about the taxes, I paid them. This is my house. I think the sole question with respect to my client is, did that put him on notice such that he was no longer a good faith purchaser? And my argument would be that he had no reason to believe if that statement were true, the sale would have been confirmed. And that to require him to take additional steps when we're not facing an insufficient bid, he didn't bid $22,000 for this property. He bid $407,000 for this property. It was not an underbid situation. It was not a case where he knew there was a renter in the property and maybe the owner didn't have notice. It wasn't a case where we all knew she lived somewhere else and wasn't getting notice. The facts are simply different here. It is just a self-serving statement by the debtor that she has paid her debt, when the party to whom the debt was owed is indicating otherwise.
And under 105-361 regarding the statement of amount of taxes due, A1E, under who may make a request, any of the following persons may request their certificate. And E is a person or firm having a contract to purchase or lease the property, or a person or firm having contracted to make a loan secured by the real property. Do you have any dispute that Belk would fall within that category of 1E?
No.
Would have had a right to request a certificate?
I believe he could have requested under that statute. Would the county have provided it? I don't know. But I believe he was entitled to request it. Do I believe he should have been required to request it? Absolutely not. Your Honor, Your Honors, we've already discussed nothing brings the house back. The house is no longer there. If we are looking at what the options are, I do not believe title should be divested of Mr. Belk. I believe he was a good faith purchaser. I believe the trial court found competent evidence to find that he was a good faith purchaser, which should not be upset. If we look at what Belk's options were when that note was posted, he could forfeit $20,000. So we are saying, in foreclosure proceedings, if you're the debtor and you stick a note on your door saying, I paid my taxes, the bid is now forfeited. Or he could trust that if the note was true, the sale wouldn't be confirmed, he would never take title, and he would never find himself in this situation. Mr. Belk had no actual or constructive notice that ever put him on notice that he would find himself here today. This was not a risky transition for him, or a risky transaction for him. What's inside the house is a risk. You never know what you're getting when you go in. But the party claiming the debt indicated to him that the debt was owed. And the party that has every interest in telling him they have paid is the only thing, the only, quote, deficiency in this proceeding from Mr. Belk's perspective. Otherwise, there is zero in the court file, and there was zero in the court file at the time of his bid, that ever would have put him on notice that there could be a problem or that he would find himself here. Or I assure you, he wouldn't be here. Thank you, Your Honors. I'm happy to answer any other questions.
All right. Thank you, counsel. All right, first round of rebuttal, I believe.
I understand I only have 7 seconds, so I'll make it as quick as I can. To the extent that Mr. Lord was referring to 105-361, the county's pled Rule 2 in the reply brief to address that. And then also on page 149 of the record, Ms. Ryan made reference to $503 of card fees that she paid. That also caused some question about what the exact amount was that she paid and that was refunded. Thank you.
All right.
Unless there's any question.
Thank you, counsel. Second rebuttal.
Thank you, Your Honors. I realize that I'm also very low on time for rebuttal. I want to primarily address Ms. Hunt's arguments with respect to Mr. Belk. Ms. Hunt made a point of saying how much money is in with the clerk of court. Your Honors, that is surplus money. That is money that would belong to Ms. Ryan irrespective of anything that happened. If this sale is consummated, she's always entitled to that. That is not restitution, and that is not anything special. That is just money that she or any taxpayer would owe, regardless of would own, regardless of whether they had paid the taxes. You know, Ms. Hunt makes a point of saying that Mr. Belk's options were either to forfeit his bid and the deposit that he put down, or to trust that the county and the process would work. That is not the law. The law is if you have notice, actual or constructive notice of a defect in the sale, then if you go through with it, you are not a good faith purchaser. That is the law. And so, as Judge Murphy pointed out, he does have other options. He could have made a very easy written request to the county, and if the county had told him wrongly, then again, he's got a cause of action against the county because the county has screwed up.
Is that an issue of law that we can now determine in light of George anew, or is that something that is more akin to a finding of fact that the trial court should be making in light of George anew, and should be remanded for findings on that.
I believe that this court can find that. Again, as you pointed out, Your Honor, in one of your questions, you asked explicitly about finding of fact number 21. Is it disputed? It is not. There is no question of fact whatsoever about the fact that Mr. Belk knew prior to the time that he paid the money and prior to the time that the sale was confirmed that this defect, the very defect that brings us here, was present in this transaction. He knew. And in fact, you know, Ms. Hunt talks about what the trial court could have known and what the trial court could have said, but the fact of the matter is that the trial court made it very clear what she was basing her decision on. Judge Havelka based her decision on the timing issue, which was the sole issue with respect to the good faith purchaser status in front of the trial court. In my view, it is the sole issue in front of this court, is whether the knowledge of a defect in the sale prevents you from being a good faith purchaser, whether that determination is made at the time you make your bid or at the time of purchase. And I would submit to the court that all of our law is clear that it is as of the time of purchase, not as of bid. And I think that the trial court got that wrong, and I think that this court has the opportunity to correct that mistake, because all of the law, again, it's very clear. It's you're a good faith purchaser, not a good faith bidder.
Thank you, counsel.
Yes, Your Honor.
All right, we thank
Thank
the
you, Your
parties. We thank the parties for their arguments, and we will adjourn. Mr. Clerk?